Shalom, friends. Good evening from here in Jerusalem. Good afternoon to those who are on the in the Eastern time zone, and if anybody is from a different time zone, welcome. Today's session is intimate and small by design. We suggested, following Alan Baker's fascinating exposition of the two international courts that are located in The Hague, and that Israel has found itself engaged in and confronted by proceedings in both courts. So Alan was presenting to us an enlightening picture of what this is about, and for the less informed, less experienced in the field of international law, and the previous session was intended for a mixed audience. He explained about the two courts, their respective authorities, and what exactly was Israel's exposure in both, and where did it stand then, and what may it lead to. And Alan could do that so professionally and clearly, because Alan Baker is former legal advisor of the Israel's foreign ministry, and we go back together many years before that, to the time that we both served in the Judge Advocates Division, and Alan served in the International Law Department of the JAG. I was in a different section, and of course, to add to that, Alan served as Israel's ambassador to Canada, and he's currently at the Center for
Foreign and Security Affairs.
Exactly, great. So clearly experienced and qualified to provide us with the deeper analysis and understanding of these unprecedented and important challenges that Israel is facing. And we suggested that we do a follow-up, more intimate meeting. For the time being, I'll mute everybody, and Alan, when you speak, and later when Peter moderates, unmute yourselves. So when we scheduled the previous meeting, we felt that a follow-up meeting may be desirable, both as a service to JPLAN, the Jewish Pluralism Legal Action Network, members, and because we realize that this topic has a special interest and dimension, a professional dimension, to lawyers. So we suggested that we do a follow-up session with Alan that's less of an introductory session and more of a Q&A. And unlike our usual practice to urge people to write their questions or comments on the chat, with the small group, our intention was to invite you to open your mic and ask your questions, and make it a much more lively exchange. The session will be moderated by Judge Peter Buchsbaum, co-chair of JPLAN, the Jewish Pluralism Legal Action Network, and David Light, who is now on the New Jersey governor's team, right?
I'm an assistant attorney general for the state of New Jersey. So I report indirectly to the governor, more directly to the attorney general.
Great. So David is also co-chair, and the third co-chair, Mark Enshen, unfortunately could not be with us. He had a conflicting commitment. So before I turn it over to Peter, it was suggested that I say just a few words about the dramatic decision of the Israeli Supreme Court today. And I'm sure that those of you who are following the news from Israel could catch background information about it in your respective, media of choice, because it was so widely covered. And what we are talking about is a unanimous 9 justices of the Israeli Supreme Court decision regarding 2 questions. One is the draft of yeshiva students, and the other, connected with it, is the question of the large-scale funding that yeshiva students are enjoying, and a legal challenge was launched as to whether that funding may continue now that there is a question as to whether their non-enlistment, non-draft constitutes a bar bars the government from funding them. There was a third sort of last-minute petition that was put together with the others, which highlighted a different angle, which I'm sure would be of tremendous interest to you, probably all of you. And David, now that you corrected me as to your association with the Attorney General of New Jersey, that is really the topic, namely the unique role of the Attorney General in Israel, which is completely different from that of the US. And to some extent, this is, I would say, in terms of the Israeli legal system, that ruling today, or that challenge that the government initiated and was sort of stopped by the unanimous ruling today, is as important as the issue of the draft, because it goes to the core of the Israeli legal system. In one sentence, and that sentence has been stated by the Supreme Court today, the Attorney General in Israel is the binding legal authority on the government and all the executive branches of government, short of a contrary or different decision by a court. Namely, the legal advisor or the Attorney General is not the one who is providing mere advice to the government and its agencies, but rather the one who interprets to all state agencies and all public agencies what the law is, and the Attorney General's interpretation is binding on those agencies until and unless there is a different ruling handed down by an authorized court. What happened here is that the gap between the Attorney General's restatement of the laws or interpretation of the laws and the attempts of the current government to promote policies that stand in conflict with the Attorney General's interpretation has expanded and has become more frequent and more severe, to the point that, and it happened sometimes in the past, when the Attorney General agreed that the government would be represented in the Supreme Court petitions by a private attorney because the position of the government was in such conflict with that of the Attorney General, the government intended to use that exception for separate representation to mean that that private attorney could now provide them with legal counsel, and they were exempt from following the Attorney General's interpretation of the law, to the extent that that private attorney provided them with a more suitable guidance that suited their interests and political needs. So this is the last section of today's 42-page ruling, unanimous ruling, 9 justices, and that section reaffirms the system of the Israeli public law in which the Attorney General and only the Attorney General has that authority to instruct the state agencies as to their legal obligations. I am sure that that is very different from the system that you are accustomed to. Why that is the case, how it developed, we'll leave for some other time. The essence of the ruling, as I said, had to do with 2 things. One is that for 7 years now, the law that was passed and attempted to legitimize and legalize the mass exemption of yeshiva students from military service, 7 years ago, the Supreme Court declared it to be unconstitutional, primarily because of the severe breach of the principle of equality. And for 7 years now, the court has been giving the government repeated extensions to pass a law that would regulate the draft and the exemptions from the draft of yeshiva students that would be in keeping with the Supreme Court guidelines. And first and foremost among them is the principle of equality, namely that you cannot exempt one sector of the population, which in 1948 involved 400 young people who were saved from the European Holocaust and exempted them from entering into the war. From those 400 in 1948, the number today has reached well over 100,000, and specifically the number that's quoted in the ruling is 63,000. And again, I won't enter into the reason, but the number of yeshiva students who are exempted, basically the whole young generation at draft age of the Haredi community, is exempt from military service. That the Supreme Court declared was an unacceptable violation of the principle of equality, where everybody else, and we put the Arabs aside, but everybody else in the Jewish community is obligated to serve. For men, it's a 3-year service, some changes. So what the court tolerated for 7 years with repeated extensions, because every time the government asked for postponement, at one point it was because we are nearing elections, and then it was we just had an elections and we need to have time to consider it, and then again the government fell and we are nearing new elections and we need more time, etc. That lasted for 7 years. At this point, the law that was in effect and received those repeated extensions expired, and the Supreme Court today said there is no more a law on the books that legitimizes and authorizes the mass exemption, and therefore there is no basis for continued exemption, and therefore they are all under obligation to serve. Specifically, the numbers that the state, the army, reported to the court was that they were able to take in the coming year 3,000 on top of the previous number of those that actually drafted, which they claim is 1,800. So only an additional 3,000 in the coming year, based on the court ruling, will be drafted. The other aspect of the ruling is that and two of the petitions focused on that aspect is, well, now that there is no legal basis for the continued exemption of the yeshiva students, there is no legal backing, no legal basis to continue subsidizing them during their yeshiva studies. The court unanimously accepted both aspects of these petitions and ruled that at this point, and until there is an other law which would pass the constitutional inspection, so to speak, there is no basis for exempting any yeshiva students, even if temporarily only 3,000 additional yeshiva students would be drafted. But in principle, no one can now be exempted, and no funding can be flowing from the treasury to subsidize those yeshiva students that no longer have an valid exemption or postponement. Took longer than I intended, but it's pretty dramatic, and we'll leave it at that and turn to the topic at hand, the Hague courts, and Peter, you are the moderator.
Okay. Hello, everybody. Ambassador Baker said he has to leave by 1. So I think what we'll do is put the burden on you to speak for about 10 minutes or 15 minutes, Alan. And then we'll open it up for questions, or we'll do it that way so there's a chance to interact with you. And if you want to welcome questions at any time, that's entirely up to you. So, but we would like to have a chance for our audience to ask you things about jurisdiction and some of the other legal issues that have come up that you mentioned in your first talk. So with that, I will turn it over to you.
Now, if you want to speak or ask, please use the, I don't know what it's called, but the feature in Zoom that enables you to raise your hand, and Peter will see you and acknowledge you.
Okay. Thank you very much for returning, Alan. We appreciate it. Let's
okay. You're very welcome. Let me just very, very briefly summarize more or less what I explained at our last meeting. We're talking about two completely different courts. The first one is the International Court of Justice at The Hague. This is a United Nations organ. It's principal judicial organ, but it's the UN. And I say that deliberately because one has to take into consideration that everything that happens there is part and parcel of the functioning of the UN, with the minuses and maybe a couple of pluses that implies. The ICJ, the International Court of Justice, is involved in two issues regarding Israel. One is a direct litigation initiated by South Africa at the behest of Hamas and with the financing of Iran, accusing Israel of violating the UN anti-genocide convention. And this is a specific field. Jurisdiction only exists with regard to this question of whether Israel is in violation or has violated or has not violated. And there have been a couple of sessions. The South Africans keep coming back with requests for interim orders, which the court, some of them has agreed to issue, but none of them include a call to stop Israel's armed conflict with Hamas. This is going on. It will take a long time. Israel has appeared before the court. Israel has presented its legal responses to the very curious accusations by South Africa, which basically they're asking the court to micromanage the war, and the court doesn't have the jurisdiction and doesn't have the capability of doing that. But one can't forget the fact that of the 15 judges, they're all appointed by their countries, and the large majority of them receive their instructions from their countries. That's why I opened by saying that this is the UN, and it's highly unlikely that that anybody can expect justice to come out of this thing. Although it's potentially very damaging to the court if the court becomes overly politicized. Up to now, it's tried to keep itself far from being politicized to the same extent as the other UN organs. But this attempt by South Africa, Hamas, and Iran, with the addition of several countries that have joined, has a great danger of politicizing the court and prejudicing the integrity and the capability of the court, the credibility of the court to continue functioning as a juridical body. So that's ongoing. The assumption is that it will take a long time, possibly over a year, before the court comes up with any determination or judgment on the issue. The legal issue at hand is, as required by the UN Genocide Convention, whether the accused has expressed the intention to commit genocide. Not just committed genocide, but the definition of genocide is after having expressed the intention to commit genocide. And of course, Israel's basic response has been that Israel's fighting a war of self-defense, anti-terror against a very cruel terror organization. And it's only against a terror organization. There's no intention of causing a genocide of the Palestinian people or of the population of Gaza, only against Hamas. And these points have been very clearly made. So that's with respect to the first issue of the International Court of Justice. The second issue is the second function of this court, which is to give advisory opinions requested by various UN organs on issues of international law. These advisory opinions aren't binding, as their name implies, they're advisory. And the issue at hand is a complaint or request by the Palestinians who have a sort of quasi-state status in the United Nations as a non-state observer, or a non-state observer, and they requested an advisory opinion on whether the prolonged quote-unquote occupation by Israel of Palestinian territories is not a violation of international law. This was opened up for legal opinions by all states who wanted to issue opinions, and by other international lawyers and various organizations, and hundreds and even thousands of these opinions have been presented to the court. And within the next couple of months, the court will start to discuss this issue. The second court is the International Court of Justice, which ostensibly is a completely independent institution. It's not part of the United Nations, but it is recognized by the United Nations and receives services from the United Nations and has a relationship agreement with the United Nations.
Sorry, I think you mean the International Criminal Court. You
Yes,
said
that's what I said. Sorry. It's the International Criminal Court. They both sit in The Hague, and it's very confusing to anybody who's not familiar with the differentiation between the two courts. This is a court that deals with individuals. In other words, it deals with claims against individuals, not against states. So anybody who has presented a referral to this court complaining about war crimes, crimes against humanity committed by individuals, leaders, military leaders, officers, individual soldiers, can be subject of claims presented to this International Criminal Court by members of the court and by the Security Council and by any individual who wishes to present a petition of his or her own initiative, if the court accepts it and agrees to the fact that it has jurisdiction. The issue here is that Palestinians claim, because they've been upgraded to a sort of non-state observer member of the UN, they're claiming that this grants them membership of the court as a state, because the statute of the court is restricted only to sovereign states and only to states that have sovereign territory. And as a result of this, the Palestinians are claiming that because they're a state and because the court has accepted them as a state, then they have territory, which is the occupied territories, Judea and Samaria and the Gaza Strip. And therefore, since Israel is, according to them, committing, or since Israeli leaders are committing war crimes in Palestinian sovereign territory, then the court has jurisdiction. Of course, Israel, whilst it's not a party to the statute of the court, despite the fact that we were heavily involved in negotiating and drafting the statute, I personally was involved. But Israel, because of the politicization of the statute by the Arab countries, Israel, the United States, Russia, China, and several other countries, in fact, the majority of the population of the world, haven't become party to this court. But those who have issued legal opinions, including the organization for which with which I'm associated, the Jerusalem Center for Foreign and Security Affairs, we have issued a detailed opinion together with other legal organizations in Israel, absolutely abolishing the claim that the Palestinians have jurisdiction and abolishing all the various claims made by the Palestinians. The one other point regarding to this court is that if a state has the capability and the willingness of using its own legal system in order to deal with complaints against its leaders and against its military officers, then the International Criminal Court can't use its own jurisdiction. And since Israel has got a very highly advanced and well-regarded legal system, then this is another point that the various Israeli organizations and others have stressed. So this is the position. Up to now, there's nothing new except the request by the prosecutor of the International Criminal Court to issue arrest warrants against Netanyahu and Israel's Minister of Defense, Gallant, and against a couple of the leaders of Hamas, Yahya Sinwar and Ismail Haniyeh, all together, bunched together as if they're all in the same basket. This was a request put to the pre-trial chamber of the International Criminal Court. This pre-trial chamber hasn't determined yet, and as I said, with respect to the International Court of Justice, it's highly unlikely that they'll do this, because this will bring the International Criminal Court deep into the Israel-bashing group of organizations, and will basically destroy any claim that it's ever had to be impartial and completely unbiased. So this court has a huge problem, and I'm quite surprised that the prosecutor, who up to now I've always highly respected and considered him to be a very solid barrister, British barrister, not given to being influenced by political considerations, for some strange reason, which I really don't know, he came out with a very nasty report explaining why he's issued the arrest warrants, accusing Israel of famine and violations of the international humanitarian law and war crimes. I personally don't believe this will happen, but there again, politicization is politicization, and the judges of the International Criminal Court are also appointed by the same system as the International Court of Justice, the UN system of geographical groupings. So anybody who expects complete unbiased consideration by either of these courts, I think that they shouldn't hold their breath. That's about it.
Okay, thank you very much, Alan. Ordinarily, questions of jurisdiction are handled first, particularly of the jurisdiction of the ICC in light of the Israeli independent judiciary, which is just reaffirmed by the decision that Uri described earlier, and also the non-state situation of the Palestinians. Is there any chance of any objective and reasonably speedy determination by that court, which I understand has a Lebanese Chief Justice now, of the jurisdictional issues, which normally would be handled first in any proceeding?
Well, Peter, you're mixing up the ICJ and the ICC, because the ICJ, the International Court of Justice, which is the court dealing with the South African...
Right, I understand.
So they have jurisdiction, Israel and South Africa, both being party to the Genocide Convention, have agreed in advance on signing that convention to accept the jurisdiction of the International Court of Justice on any issue arising regarding the implementation of the convention. So that's not an issue. What is an issue, in my view, is the fact that the president of the court, the Lebanese judge, didn't recuse himself, especially in view of the fact that in his previous job as their ambassador to the UN, he's on record of attacking Israel and accusing Israel of apartheid and all sorts of nasty things, and he didn't choose to recuse himself when dealing with the various requests by South Africa for interim orders. So here is a point of jurisdiction, which I would have hoped that the Israeli team dealing with it would have pointed this out. I don't recall that they did this, because they were very hard. They had to appear before the court within 2 days, and so they didn't have much time to prepare themselves. With respect to the ICC, the International Criminal Court, again, the issue of jurisdiction is that they claim they have jurisdiction because they're a sovereign state. Israel claims that they don't have jurisdiction because they don't exist as a state at all. And even if they did exist as a state, the question of the permanent status of the territories has yet to be determined, and this is agreed upon by the Palestinians in the Oslo Accords and most of the other states who have all endorsed the Oslo Accords. So even if the Palestinians were a state, or if the court did have jurisdiction, the territories aren't sovereign Palestinian territory. The issue is still open as to what will be the final status of the territories. So, if the court takes this very seriously and deals with it professionally and not politically, then there's no way in which the court can accept jurisdiction from the Palestinians and accept the fact that Palestinians have the right to petition the court.
Okay, thank you. I think in the case of the ICJ, I had more in mind the issue of intent and how that would be handled. But there were several questions that Shalom Schechter asked, and I have just asked him to unmute himself. He put them in the chat. But Shalom, do you want to speak up at this moment?
I'm trying to read his question.
Oh, I can look at the chat and read the questions.
Well, first of all, Shalom, I think the first question that you're asking, I think you're assuming wrong. The fact that various people are saying that whether it's possible or not possible to completely destroy Hamas, or you can't destroy the idea, but you can destroy the military capability, these are individuals expressing their opinions. The government of Israel, it's not the Netanyahu government, it's the government of Israel, is responsible for any loss of civilian life that's caused through committing violations of international humanitarian law. But most of the loss of civilian life in Gaza is because the Hamas were using human shields and storing weaponry and firing from civilian homes and hospitals and schools and mosques, and therefore any loss of civilian life was a result of the fact that these were legitimate military targets according to international humanitarian law, and therefore the Israeli government isn't liable, doesn't have international legal liability for such loss, as long as the targets targeted were legitimate military targets. Second question, does the delay in appointing a new Chief Justice for the Israeli Supreme Court and other actions of the Netanyahu, or the Israeli government, to interfere in the independence of the judiciary weaken the Israeli defense in the International Criminal Court? Well, first of all, the attempt before the war began last year to reform Israel's legal system was dropped. It failed. Had it succeeded, there might have been a possibility of claiming that the Israeli Supreme Court has been weakened and doesn't answer the criteria for being an independent court capable and willing of trying criminal proceedings. But in my opinion, even had the legal reforms been accepted, or some of them, this wouldn't have changed the nature or the independence of Israel's Supreme Court. And while some might have tried to claim that, I don't think such a claim would hold water. And in any event, Israel's legal system at the moment and for the foreseeable future is a very solid, highly regarded legal system, as I said.
Okay. Leo Adler raised his hand, so
Thank
Leo,
you.
We can unmute you.
Thank you. Alan, it's great to see you again. I happened to be in The Hague about 2 weeks ago because of the moot, the student moots that was taking place. And one of the discussions was about the ICC's assumption of jurisdiction. And one of the things that they kept insisting was that they now have jurisdiction over Russia, which is why Putin's, there's an arrest warrant out for him. And they just issued 2 arrest warrants for 2 Russian generals today or yesterday. And so their argument is that the minute, and as you know, if you have a quote unquote a victim or someone who's a party to the ICC, they can assume jurisdiction. And they're talking about doing ex parte trials. Have you been involved in this, in any of the conversations involving Putin? Because they're using this as the basis for going after Netanyahu and the defense minister.
Well, first of all, no, I'm not involved in anything anymore. I'm retired, and apart from the research institute that I'm involved in, I'm not privy to any of the activities taking place by the Israeli government or the Israeli authorities, which is their choice, not mine. With respect to Putin, look, as far as I know, Ukraine is a party to the International Criminal Court, and the crimes that have been committed on Ukraine, crimes that have been complained of, are committed on Ukrainian territory, and therefore the court can claim jurisdiction, and has done so, and has issued an arrest warrant against Putin himself. Not that it worries him very much, because it's highly unlikely that he'll ever find himself being anywhere where anybody would dare to carry out an arrest warrant against him. But be that as it may, now they've issued arrest warrants against the defense minister and another officer. Again, I don't think that anything will come of this, because there have been several arrest warrants issued against African leaders in the past, and ultimately these have been cancelled by the court, or simply nothing has happened. With respect to the Palestinian claims, there really is no jurisdiction, because the Palestinians don't have territory. Why were they given recognition in the first place? Because the Secretary General of the United Nations is the depository of the Rome Statute of the International Criminal Court. A depository means that states becoming party inform the depository, the Secretary General of the UN, of their request to become party, and he rubber stamps it. The same with the Palestinians, because the Palestinians were upgraded by the UN General Assembly without any logical reason. So the Secretary General said, well, since they're acknowledged by the UN to be an observer non-state, therefore we can only answer the ICC by saying, well, yes, they are a state, therefore they should also be a state party to the Rome Statute. Now, therefore, by claiming that they're a state party to the Rome Statute, they're claiming that they have territory. And this territory is what they claim to be the occupied territory, which are sovereign Palestinian territories. And therefore, they have the right, in the same way that Ukraine has the right, to refer complaints against Israel, claiming war crimes by Israel. By the way, I'm also a potential a criminal, because I live on a settlement, and according to the Palestinians, any Israeli who takes part in settlement activity is also a war criminal, and so I am also potentially part of Palestinian complaints.
I'll be very happy to defend you.
But you can bring me flowers. You can bring me
just a
flowers
point. Ukraine is not a member of the ICC. And as a matter of fact, that's why what they were also discussing was whether the European Union, in some fashion, could, they were trying to think of different ways, albeit I agree with you, and they all agree, there's no way that Putin himself will ever appear, in the dock. But they're talking about the whole concept of ex-parte trials, and they're saying that perhaps even the European Union, given Ukraine's application for membership, and given the spillover into Europe, would have jurisdiction to do an ex-parte trial.
No.
That's the concept that I was thinking.
No, don't buy it. No chance. No way.
Okay.
No way.
If I could, if anyone else wants to ask a question, but I had one thing in mind. Ultimately, Brown versus Board of Education was enforced by Eisenhower sending troops in. What are the enforcement mechanisms here? Does everything have to run ultimately through the Security Council to get, if there is any kind of judgment in either court?
Well, with respect to the International Court of Justice, which is a UN organ, they have no teeth. There's no international police force that they can send to arrest a state. The only thing that they can do, if they come up with a judgment against Israel, they can then, the proponents or the initiators of the claim, in this case South Africa, would then refer the issue to the Security Council, and ask the Security Council to enforce either economic sanctions or send military force in accordance with the 7th chapter of the UN General Assembly, the UN Charter, if that would ever happen. And of course, Security Council is subject to veto powers by not just by the United States, but also by the United Kingdom, by France, Russia, and China. And so the chances of any actual action being taken as a result of any such judgment, if and when it materializes, is highly unlikely. With respect to the arrest warrants by the International Criminal Court, again, because it's not a UN organ, so the only thing that could happen would be that if the ICC were to issue ultimately an arrest warrant against either Israelis or against the Palestinians, I think it's highly likely that they will issue against the Palestinians. I don't know whether they'll dare to issue it against the Israeli leaders, but if they do, then again, the Palestinians will then initiate a request to the Security Council, asking for Security Council action. So we're more or less running into the same sort of filter of Security Council action, again subject to veto power by the permanent members. So I'm not falling off my chair with worry. I'm bald because that's from bashing my head against the brick wall negotiating with Palestinians for years and years. But Leo is even bolder than I am. I'm really not that concerned about these international juridical actions. It's interesting. It's an interesting process, but I think both of these courts are playing with fire, in as much as they're enabling their own their manipulation by outside elements who don't really care about these courts. All they're interested in is hounding Israel for one reason or another. And the last thing that these courts need, and I participated in the drafting of the statute of the International Criminal Court, and I was, Israel was one of the first countries to suggest creation of an International Criminal Court after the Holocaust. And so, Israel has always had a very vested interest in bringing to trial the most notorious criminals, international criminals. And so for Israel not to become party to this was a huge problem for Israel. But we had no choice because of the politicization. And the court is well aware of this. And because if it becomes politicized, then a number of other countries will get up and leave. And it will place in question its whole integrity and credibility.
Well, Colin, thank you for the clear answer. David Light has raised his hand, as co-chair of JPLAN. David?
Yeah, thank you for those comments, Ambassador. I hear you on why you're, less, I think you put it as not falling off your chair with worry about what the courts are going to do. And I guess, and I'm certainly not an expert on these international courts the way you are, but I guess I agree with you to the extent that they don't really have any enforcement teeth. But I do have significant worry about the political fallout or the political ramifications of judgments from these courts that are bad for Israel. I imagine that those of us who are pro-Israel will be arguing about how, well, look at the composition of the court, and this is why it came out that way. But nevertheless, when you have those kinds of judgments out there, it seems to me that Europe is going to become less and less supportive of Israel. It seems to me that it's going to be, maybe you're laughing because it's not so supportive already, and I'm not arguing with you. But it also seems to me it puts pressure on certainly the Democratic Party in the United States for why they should distance themselves from support for Israel. I don't really see great things for Israel either by the Democratic Party moving away from its traditionally close ties with Israel, nor from the result being, well, Trump gets elected and that's going to be better. So I agree with you that there's no real enforcement teeth, but it seems to me that there could be real political ramifications of bad results in these courts, and frankly, I do see real risk that there's going to be bad results in these courts.
Okay, David, it was a bit difficult to hear you, but I think I grasped most of what you said. Look, no doubt. Look, any judgment against Israel or against Israelis or arrest warrants, obviously it's not good for business, quote unquote, and it could well affect trade relations between countries, especially Europeans and Israel. But the relationship between Israel and Europe at the moment, I don't know whether it can get much lower than it already is. There'll be countries like Ireland, Spain, Slovenia, and others who, okay, they'll stop any trading that they have with Israel. I don't know whether they have, and I don't know whether it's worth anything. I don't think it's likely that the French and the Italians and the Germans and the British will carry out sanctions against Israel, which is a friendly country to them, and they're fully aware of the politicization or the politicized nature of all these claims against Israel. So we can't rule out some damage from this type of thing, but I think that the main brunt of the serious responsible states, not just in Europe, but the United States as well, and even Canada, despite its present prime minister, who's not really the epitome of anything favorable with respect to Israel. I don't think they'll be carried away or overly carried away by any such arrest warrants or any such judgments. Again, the beginning and end of it is politicization. As soon as these bodies register themselves as being politicized, then this will reflect on the seriousness with which whatever they determine will be taken by other countries.
Okay, Alan, we've reached a few minutes after 1. If you've got,
have to leave. Yes.
If you have to leave right now, otherwise I'll ask people if there's any more questions. All right. My old role as a judge, hearing none. Oh, we do have one from Shalom.
Okay, quickie.
Shalom, shalom.
Shalom. I had put some questions in the chat. I'm sorry, I was balancing this with feeding my grandchildren lunch, so I'm not sure if they were answered. About the IDF saying that they can no longer.
Yeah, that one was answered.
They were answered, and you'll get the recording and see the responses.
Thank you.
Okay.
Okay. Bye-bye, everybody.
All right, Alan, thank you very much. We don't need
You're
you
welcome.
to sum up. I think your last comments in response to David's questions summed up everything we needed to know.
Thank you.
Okay.
There will
Bye-bye.
be a report and a follow-up, as Uri says, and if anybody has further questions at that point, you can just respond to Uri. Is that correct, Uri?
Yeah, and I'll forward them to Alan, and we'll probably organize a session following on today's dramatic ruling of the Supreme Court and the unfolding saga. And I noted Shalom's question regarding Haredi women. The issue of Haredi women doesn't even come up. I mean, there's no question about them not serving. The issue has a reason with regard to the current military service law or security service law that exempts all women that claim with supporting their claim by an affidavit in which they state that reasons of family tradition and religious faith prevents them from serving in the army. That is an issue that Hiddush has actually been involved with for a number of years. I won't go into the details, but the army has looked into it over the years and has come to the conclusion that thousands of secular women are submitting false affidavits claiming that religious consciousness or family tradition prevent them from serving in the army and are receiving automatic exemption based on that affidavit. The story, is a bit more complex, but that's the issue of women's service. The interesting thing is that the chief rabbinate's position is that no women should be serving, but there is an internal growing commitment of Zionist Orthodox women to actually serve and serve in combat functions. And the issue of women serving in combat functions has been a topic of controversy in Israel for some years now, with everybody or practically everybody agreeing that after October 7th, no one has any doubts or should raise any of the challenges regarding the capability and desirability and the ability of women to take an active and effective role in combat maneuvers.
Thank you, Uri. It just occurs to me, thinking about the Supreme Court opinion, the principle of equality, and there is no equal protection clause in anything like the New Jersey, the Israeli basic law, but it's there.
It's
part of
one
Israeli
of those
law.
principles that has been upheld by the courts,
Yeah,
and has become an essential part of Israeli legal tradition. It's interesting that when the nation-state law was legislated and caused such a controversy and internally and internationally, one of the attempts was to suggest to remedy some of the unsatisfying essence of that law by including the principle of equality or the protection of the principle of equality. The government wouldn't hear of it.
All right, well, Shalom has a question, and we'll use that to conclude the,
Yeah, and I think we are, I guess we are
well,
losing our,
let
our
Shalom have
audience.
his shot here.
So my question wasn't in relation to military service, but I understood that there is a requirement for alternatives to military service, Sherut La'am, other kinds of volunteer public service that women who didn't go into the military would be involved in. So I don't know if that's a legal requirement, and if it is, will that now apply to Haredi women?
So the new law is not formed yet. So we'll see what the new law would offer in terms of balancing between military service and civil service or national service. Indeed, no one seriously considers doing civil service or national service for Haredi women. That has not come up. That's not the issue. But the interesting thing is that many modern Orthodox women are indeed utilizing that avenue and are doing national service for 2 years as an alternative to serving in the army. But as I said, more and more are now opting to actually serve in the military, not just in civil service. But
Okay, with that, I think
the main needs of the army are based on the hole that was created since October 7th by the number of casualties, but the number of casualties is multiplied many-fold by those who are wounded and cannot function in the military in their previous combat capacity. So there is a hole of approximately 4,500 soldiers, active duty soldiers, and that can only be filled by not by Haredi women, but rather by drafting yeshiva students.
Okay, we've lost most of the audience by now, so I think it's time to say thank you to everybody. And you all heard that you can ask questions when you get the report from Uri, if there are any further questions. And that remark is addressed to those who are here and those who are not here anymore. But it's been a very enlightening for me session and enjoyable. And thank you, everyone, for attending. And thank you, Uri, for providing your host services. And David, thank you as well.
Thank you, guys.
And with that,
Good to see both of you.
I think a motion to adjourn would be in order. So we'll await the next seminar. Uri.
Thank you.
Thanks.
Shalom,
Thanks,
shalom.
Peter.
Shalom.